Welcome, everyone, to today's webinar, Estate Planning Considerations for the LGBTQ plus community. This webinar is presented by members of the NCBA Estate Planning and Fiduciary Law section in partnership with the NCBA Sexual Orientation and Gender Identity Committee. Today, our panelists encourage you to post questions throughout the presentation in the chat. We'll be monitoring those questions and posing those to our panelists. I did want to take a few moments to introduce you to our two panelists. First, we have Paula Kohut, who's a partner at Kohut, Adams & Randall in Wilmington, North Carolina. Her principal practice areas are estate planning, trust and estate administration, business law, and asset protection. Paula is a fellow in the American College of Trust and Estate Counsel. She received her BA from the University of California in Irvine and her JD with honors from Wake Forest University School of Law. Paula is the immediate past chair of the Estate Planning and Fiduciary Law section of the North Carolina Bar Association and is a board member of the Board of Governors of the North Carolina Bar Association. Paula also serves on the board of St. Jude's Wilmington Foundation. We are also joined today by Danielle Furman, who's an attorney at Manning, Fulton, and Skinner in Raleigh. Her principal practice areas are estate planning and trust and estate administration. She completed her undergraduate studies at the North Carolina State University, where she earned degrees in political science and philosophy of law. She earned her JD degree from the George Washington University School of Law in Washington, D.C. She is licensed to practice law in North Carolina, South Carolina, Washington, D.C., Maryland, and Virginia, and she regularly assists clients in all 5 states. Danielle is the chair of the IDEA Committee, as well as the YLD liaison to the Estate and Fiduciary Law section of the North Carolina Bar Association. And she was also recently named to the board of directors for Life Experiences, an organization based in the Triangle area, which aims to enhance the lives of adults with disabilities by facilitating their participation in day programs and job training. Welcome, Paula and Danielle, and thank you so much for being here.
Great. Thank you, Alex. Where we're going to start off, I guess, is when I came out in the LGBT community, and that was 27 years into my practice, when I would attend seminars on estate planning. Typically, the seminars related to members of the community. It was more about dealing with them as single individuals and maybe the different tax planning techniques that you could use to leverage their estate plans due to the lack of marriage equality and the marital deduction. But today, that's not going to be our focus. Today, what we wanted to focus on, what I have learned as a member of the community and realizing that I had more members of the LGBT community as clients, that there are some unique challenges that they face, and that's what we're going to try to address today. And as Alex mentioned, feel free to put questions in the chat. We'll try to answer those as we go. If we feel that we're running short on time, we'll hold those, we'll address the questions at the end or offline after the presentation. So Danielle, I think I'll turn it over to you.
Sure. So I think most people, when they hear estate planning, they automatically think of death and all afterlife, documents and things of that nature. But I think it would be great, while we have the most people on right now, let's start the discussion with life. So Paula, I want to start with you. What about planning for incapacity? What are the unique issues and challenges for the members of the community in that regard?
Well, thanks, Danielle. I think one of the big issues is healthcare decisions. And oftentimes when I started doing trust and estate work, I thought of the healthcare powers of attorney as being kind of an ancillary document. That was a small part of the planning, but particularly with members of the community, it's important to have healthcare powers of attorney in place. And the reason for that is that if you do not have those, then you're going to be defaulted to what are known as statutory surrogates. There's going to be a statute that outlines, and it's for the lawyers on the call, it's GS 90-21.13, which are our informed consent statute. And what that says is these people in this order are going to be able to make your healthcare decisions if you're incapacitated. And that is a court-appointed guardian, unless there is a healthcare power of attorney, and then the healthcare power of attorney would trump that unless the court revoked the power of attorney, or a healthcare agent appointed under healthcare power of attorney. And then we drop down to a patient's spouse. So if you're married, but if you're not married, then a majority of the patient's reasonably available parents and children who are over 18. And if none of those people are available, then we go down to a majority of siblings. And it's only when we get down to the very end is an individual who has an established relationship with the patient. So that would be the problem, is if you did not have a healthcare power of attorney, it might be that your immediate family members, instead of your partner, particularly if you're unmarried, would make those decisions. And I had an article, it was published for the members of the NCBA who are on the call in the Will and the Way. It was back in April of 2012, but I think it's still relevant today. It was prior to marriage equality, and that's LGBT estate planning, and it's volume 31, number 3. And if there's anyone on the call who doesn't have access to that, feel free to reach out to me and I'll be happy to get you a copy of the article. But I went over these rules, and one thing that I also mentioned was I always, in my interview with a client, I ask if there are any family members who might be hostile towards their relationships, their sexual orientation, or their gender identity. And because if they are, then what I want to do is I want to make sure that those persons are excluded, that the healthcare power of attorney says that those people are not appropriate people to serve as a guardian of the person or a general guardian of the person if they were incapacitated. And we don't need to say anything derogatory about those family members. We want to keep it neutral, but we want to exclude them from those persons. So that's that on healthcare decisions while during someone's life. And Danielle, what about financial decisions?
Yeah, so similarly important would be a durable general power of attorney or a financial power of attorney, to name someone to step into your shoes in all legal and financial decisions if you were incapacitated. So the same thing kind of applies here. You want to name someone you trust that understands you and your relationship and your needs and your values. And so to that end, we may want to exclude family members from this document as well and make sure that only those who are going to use your resources truly for your benefit and in the way you would use them are those that can step into your shoes. Another thing that I think is a unique consideration that we might want to highlight is not only the financial decisions, but does the healthy partner, if you're unmarried and you cohabitate with your partner, do they have the right to live in the house, to use your assets for their support, just like they would if you were alive? Or sorry, you are alive, if you were not incapacitated. So this is something that I think is important to specifically call out in the documents. You should make sure that you make provisions for your partner, especially if there are adverse family members who may not respect that, who may view them as a roommate or something like that. We want to really value your relationships and call them out specifically, so that there's no question that your loved one can stay in the house and can, use assets as they need. So there is a statutory form, power of attorney in the North Carolina statutes, which is a great starting point. That being said, it is very general and it doesn't include things of this nature. So this is something that we would highly encourage you actually seek out legal counsel, and particularly someone who is sensitive and understanding to your situation and the dynamics at play, so that your partner can be protected there. Even if your partner is named as the agent, we'd want to call out those specific provisions benefiting them in the document, so that no family members can say that they are self-dealing or using the money in ways that you wouldn't actually want. So that is what I'm thinking about the financial decisions. So we've talked about all the life stuff now. If we want to hop into funeral arrangements and final wishes, Paula, do you have thoughts on that?
Sure. And one, I apologize for the fire truck. We're right around this corner from a fire station. I'll try to mute my microphone if that happens again. And before we leave powers of attorney, that Danielle mentioned something that I think is very important. While it's not as common anymore now with marriage equality, there are still some couples, they're typically older, that have not come out to their families. It's kind of a don't ask, don't tell approach. And that's where it's so important, as particularly if they're not married, that you have protections in the power of attorney. And that would, for the non-lawyers on the call, that would be something that you're not going to capture just in the statutory form that you pull offline, but it's something that you need help from a lawyer to prepare. But funeral arrangements are very similar to the healthcare powers of attorney. Again, there's a good article in that Will and the Way article publication that I mentioned back from April 2012. There's a great article by lawyer Mike Anderson, Dust to Dust, and he refers to the fact that under North Carolina law, a healthcare agent does have authority to handle the final disposition of your remains. So now you've died, and then who is going to be in charge of your funeral arrangements? But if you don't have that document, then there's a list again of statutory surrogates that's very similar to the informed consent statute. But you can also appoint separately in a separate document an agent to handle the final disposition of your remains. When I started working with the LGBTQ community, I had read about these forms. Joan Berta, prior to marriage equality, was she had published a few ABA, American Bar Association publications on estate planning for same-sex couples, and she suggested using such a form so that the funeral director has a clear direction on who to take directions from. And that may be an unmarried partner and not the next of kin. And the more I've used that form, now I even use it for my cisgendered straight clients, because it just makes clear maybe there's one of three children that the parents want to handle. They're conveniently located in that area, and it makes clear, it just gives the funeral director clear direction. So I like to put it in a separate document. And again, as we mentioned before, I like to have a conversation with my clients to find out, are there any members in the family that might, immediate family members who might be hostile to their relationship or their gender identity. There's a woman here in Wilmington, she, transgender woman, she had transitioned many years ago. Her family was from Michigan. She died unexpectedly very young, and she didn't have any documents in place. And her family came in, and just from within the community, friends, we knew that her family did not respect her gender identity. So it was the worst of all worlds for her. And if she would have had those documents in place, someone would have respected her gender identity in her final illness and also in her final affairs. So it's very important. And now getting to not lack of capacity, but death. Danielle, what happens if I die without a will? I think that's a good place to start before we talk about wills and trust.
Certainly. So for the non-lawyers in the room, dying without a will is known as intestate succession. And so we have specific statutes in North Carolina that dictate the distribution of your property if you die without a will. Not only do they dictate the distribution of your property, but they also dictate who has the priority to be in charge of administering your estate. So you don't get to pick your executor, obviously, if you don't have a will. And so the statutes would provide that your spouse would be the executor, but if not, then it goes down to your next of kin. And your unmarried partner does not have any standing to open that estate until potentially all the way down after all of your creditors. So it's definitely not something you'd want to leave to chance. Another assumption that most people make is, okay, well, no worries, I am married and everything will just go to my spouse. surprise, North Carolina intestacy statutes actually throws a bit of a curveball there. So first I'll talk about if you pass away with a spouse and you have surviving children, we're looking at a few different delineations here. So for real property, if you pass away and you have a surviving spouse and a surviving child, half of that real property goes to your surviving spouse and half of that real property goes to the surviving child. Looking at the personal property, so everything other than your real estate, the first $60,000 plus half of the remainder goes to your surviving spouse, and then the rest goes to the surviving child. If we're looking at 2 or more children, we're cutting all of that even further. So if you have 2 or more children, your spouse only gets 1/3 of your real estate, and they get $60,000 of your personal property plus 1/3 of the remaining personal property. So to give you an example here, if a deceased died with $200,000, 1 child, 1 surviving spouse, the surviving spouse would get the first $60K plus $70K for the half of the remaining $140K. And then the child would get $70K. And then in regards to the real estate, the spouse and the child would split the real property, and each of them would be 50% owners. So that's something that people don't typically expect. The bigger curveball is if you don't have children, we're involving parents at this point. And that's something that I have found couples shocked by every time I've let them in on that little secret. So if you have a surviving parent, but no children, the spouse gets half of the real property and the surviving parent gets half of the real property. So if you don't own your home tenants by the entirety and you don't have estate planning, suddenly your spouse and their in-laws are co-owners of your home. For personal property, again, if there's no kids, but there is a surviving parent, the spouse gets the first 100,000. So this is more than the first 60,000 if there's children. They get the first 100,000 plus half of the remaining personal property. And then the parents get the other half. So to put that in an example here for you, if a deceased dies again with $200,000, no kids, but they have a parent surviving and a spouse surviving, the surviving spouse gets the first 100,000 plus 50K for the half of the remaining 100K, and then the parents get 50K. And then, as mentioned before, the parents and the spouse would split the real property and each get half. So we're looking at co-owners of your marital home. You might think this is a remote possibility, and that's understandable. We all think we're invincible. We think we're going to outlive our parents, etc. However, I will say I have an estate right now with a man in his 70s, and he did not have a will. So his wife of 40 years and his 98-year-old mother are now co-owners of their marital home. And that has been an interesting dynamic that we've been having to parse through. So never say never. Last thing I wanted to add here too is partial intestacy is also an option. And so that means if you do have a will, but for some reason it specifically calls out certain assets and does not address everything, then those assets that are not addressed would pass through on these intestacy statutes. So that's another reason, and segues perfectly into why I would like to hear from Paula the benefits of having a well-drafted will.
Before we
yeah.
launch into the will, Danielle, we did have a question come in from an attendee. And the question is, when marriage rights may be under attack in certain states this election season, is there anything a same-sex married couple can do to strengthen their spousal rights? Is that where the power of attorney comes in?
I would think, yes, it's good to have those documents in place. We're at the end of the presentation. We're going to get to what the Justice Thomas's concurrence in the Dobbs decision, which suggested that he would like to revisit Obergefell, and Obergefell for the non-lawyers is the decision that established marriage equality. And so we'll address that at the end of the presentation, but to answer the question, it is important to have these documents in place. If you're in a hostile jurisdiction or a couple moves to a hostile jurisdiction and you don't have a good power of attorney in place, you don't have a good healthcare power of attorney in place, you could have family members that are going to create trouble.
Yes, I agree. And I would just emphasize that all of these documents that we discuss here, including the will, as Paula's going to get into next, would be vital in ensuring that even if marriage equality was overturned or threatened, as it currently is being threatened, a well-drafted estate plan works for unmarried couples. So, even if your marriage is at stake, there's protection in that, as much protection as you could preserve if you had an unmarried partner. And so kind of that just highlights the importance of doing this whether you're married or not.
And that's a good point, Danielle. And that kind of is a great segue into the importance of a will and estate planning. What estate planning lawyers do. So a lot of times we think, and we'll talk about, I'll have some comments on some potential resources for people that just cannot afford a lawyer. But the value that a lawyer brings to the process is, when we do an estate plan for a client, we're not just going to do a will and ask you who your beneficiaries are. We're going to be verifying how your assets are titled. Sometimes clients don't like that; they find it invasive, but I want to know how your assets are titled. One issue is real estate, and Danielle touched on that. If you're a married couple and you've gotten prior to marriage equality, gay and lesbian couples could only own property joint with rights of survivorship, not as tenants by the entireties. And the difference for the non-lawyers in the audience are that holding property joint as tenants by the entireties provides some extra asset protection, and it's also is a very smooth transition of ownership to the surviving spouse. Joint with rights of survivorship is not quite as robust, is the way I would put it. So I always, when I have clients who have gotten married, but they acquired the property before they did, and whether they're in the community or not, we like to confirm how their property is titled. Sometimes we come up with some surprises. And so that's one piece of that. And then with a will, the advantage of a will, if you don't have a will, then your next of kin are going to be the ones to administer your estate. And that could be a family member that might not have a great relationship with your intended beneficiary. And Danielle's case is a great example of that. The 90-year-old parent may not have a great relationship with that person's spouse of 40 years. So that's the biggest thing. And again, when I'm dealing with LGBTQ clients, I always make sure if there's someone who's going to be hostile to the relationship, and even with clients who might not be part of the community, but they say that they have a difficult son or daughter, hopefully they'll let me know that, we them from being able to serve as an executor, because we know that they're going to cause problems. The other right that people have, that spouses have, if you're married, and a lot of us in the LGBTQ community, since marriage equality is so new, Oglebafel was decided in 2015. They're not aware of all the rights that a spouse has. So the day that I get married, my spouse is going to have rights to my estate, and those are called the. Sorry, I was letting the ambulance go by. Those are referred to as elective share rights. And so the day that I marry someone, my estate plan has to leave them at least 15% of my estate, and at 15 years of marriage, at least 50% of my estate, unless I waive that right in a prenuptial agreement or a postnuptial agreement. So those are the issues that a lawyer is going to help their client work through. People often ask me, I had one case, it was interesting. A couple came in and their father-in-law had this will, and I was reading the will, and it started to sound well written, but I couldn't understand who the beneficiaries were. And I kept reading it over and over, and I hesitated to ask who the lawyer was who drafted it, because I thought this is a terrible will. And but it turns out that the father had written the will. He was very proud of it. He'd taken it offline, but he intended well, but it would have ended up just in if the family didn't reach a family settlement agreement, it would have ended up in a will challenge had he not clarified everything. So pulling wills offline, or it used to be that you could get them at an office supply shop. It has its risk. If you have a very simple estate plan, that may be the best thing. I would suggest in that case that if you're a senior, the North Carolina Legal Aid Office has a senior law project, and they will find a volunteer lawyer to help you draft a will. The lawyer's not going to do a complicated estate plan. So it's truly for people in need who have a simple asset mix. And that number, they asked during Helene, I'll give you two numbers. Due to Helene, they asked that you call their general helpline, which is 866-219-5262, 866-219-5262. And I know this is being recorded, it'll be available later. The Senior Law Project main number is 1-877-579-7562. That's 1-877-579-7562. And there are also programs such as Wills for Heroes, which the North Carolina Bar Association puts on, and those provide the ability to obtain a will on a pro bono basis. But if you can afford it, generally the lawyer is going to be able to help you guide you through those issues, so you avoid a lot of the pitfalls of a will challenge. And the one thing that I would like to mention, Danielle, we didn't talk about, but you and I have heard it many times. There is a urban legend out there, if that's what it's called, that if you want to disinherit a beneficiary, leave them $1 or leave them $5. Please never do that, because what you've done now, that person, yes, if they accept that dollar, they're bound by the will, but they are now a beneficiary of the estate. They can ask for information, they can inquire. Instead, what you want to do, and the other thing you don't want to do, you don't want to say why your Uncle Bob is such a terrible person and why he's excluded from the will, because you don't want to defame that person. Instead, just have a simple statement that this is your estate plan and you have intentionally and expressly excluded Uncle Bob from your estate plan, period. End of story. Don't say any more. And again, if you think that your will is going to be contested, that's where a lawyer can provide value. And what is the value? The value is that lawyer is a witness to your competency, and that is your estate plan, and that you are not subjected to undue influence. And so the lawyer can testify to that. So that's another benefit of using a lawyer, particularly if you have family members who may come in and challenge, and that could be just a difficult child. But Danielle, why don't you talk a little bit about revocable or living trust?
Yeah. So the disclaimer to this part of the discussion is that probate in North Carolina is really not as scary as you may have heard. So there are certain states where you want to avoid probate at all costs. You know, the court fees are exorbitant and it's an impossible process. We are very fortunate in North Carolina that it is quite straightforward. And if you, need extra help, we have plenty of estate planning and administration attorneys available to us in North Carolina that could guide you through that process. Another reason that probate is not that scary is that real property is generally not considered a probate asset in North Carolina, nor are any assets that pass by beneficiary designation or joint ownership with right of survivorship. So that means generally people's biggest assets, their home, their retirement, their life insurance, we're going to see those flowing to beneficiaries outside of the probate process. And so for those reasons, the probate process in North Carolina gets smaller and smaller, to where we really don't need to be that stressed about it. However, there are still some reasons why you might want a revocable living trust. And I do want to clarify before I go into those reasons that I am discussing a revocable living trust, not an irrevocable trust. So this trust does not have any extra tax benefits. It is an extension of you. It operates under your Social Security number. But as you'll see, as we start to discuss the benefits of this, titling is what controls when it comes to probate, which is why Paula said, we always want to know how your assets are titled. It might feel invasive, but it helps us know, where things are headed and through what process to get them to your beneficiaries. So with that being said, this is a revocable living trust. This is not tax advantaged, but it is still very helpful in certain situations. So the first situation where I would recommend clients have a revocable living trust is if they own out-of-state property. So if you own out-of-state property, it might become subject to probate in the state in which it's located. And so you shouldn't assume that property is going to pass outside of probate like it does in North Carolina, though there are a few states that may do that as well. It's always going to be best practice to retitle your out-of-state property into your revocable living trust so that we have no need to open a probate estate in Arizona, is the one I'm doing right now, for someone who, I just had an acre of land, so I don't really need to do anything with it. That acre of land has become quite costly for us so far. So just keep that in mind. Among that, another option or reason to have a revocable living trust would be if you have difficult to value assets. So that includes something like a business. If you put that business into a revocable living trust, you can avoid the costly court mandated appraisals and reportings, and that would allow to your business to continue more seamlessly upon your passing. Another thing is circling back to the beginning of our discussion, revocable living trusts can be a helpful tool for incapacity planning. So your successor trustee or your co-trustee, depending on how you have your trust set up, could immediately control any assets that were in the name of your trust without the need for any establishment of a conservatorship or guardianship over your assets. So legal titling, as I said before, it controls in a lot of things, and it can be very advantageous for your trustees to have legal title and full control. So that kind of goes the extra step above a power of attorney, and that can be helpful in incapacity planning. Another benefit is privacy. So revocable living trusts are generally secret documents. And this means that they're not going to be entered into the public record upon your death like your will would be. And then in retitling assets into your trust during your lifetime, banks and institutions only required to review certain provisions. And so you get to keep the dispositive provisions of your estate plan confidential, even as you're working to fund the trust. And so, that's something that is very valuable, and I think could be very valuable to this community as well. Kind of shielding from public opinion and public view, the disposition and your assets generally. And then finally, ease. So this benefit is a bit conditional. Your revocable living trust is only as effective in avoiding probate as it is funded during your lifetime. So anything that's titled in the name of your trust while you're living will pass to your beneficiaries through the trust without court intervention. We would also have a pour-over will that attaches to the revocable trust that says anything that wasn't titled in the name of my trust at the time of my passing, go ahead and pour it into my trust for disposition. However, that pour-over will, while it's a catch-all and gets it distributed through the trust, anything that's subject to that will is going to go through that more public process. And that will and the inventories and accountings would become public to a certain extent as well. So the ease is it's easier on your passing if you put the work in now. But estate planning attorneys, at least I know myself, will help you with retitling assets, and will give you guidance, talk to your financial advisors, etc., if that's something you're willing to commit to at this point. So Paula, now we've talked a lot about the impact of having a will or a trust, especially on your spouse. For those listeners who aren't married today or are on the fence as to whether or not marriage is for them, can you tell us some of the pros and cons to consider from a legal standpoint in whether or not participants should get married?
Sure. And one thing that I'll mention at the start, particularly with clients, all clients, I need to know whether they're married or not. But with clients in the LGBTQ community, sometimes they may have gotten married and didn't realize that they needed to get divorced, or at the time that they got married, there was not, and then they wanted to get divorced, there was not recognition of marriage in their state, and so they may not have received a proper divorce. So I always make inquiry on whether my client has been in a prior civil union, a prior marriage, or a prior registered domestic partnership. So is there some relationship that they were previously part of, and make sure that that was properly dissolved if they've remarried, or if that relationship is ended, because you could have some surprises. There have been cases where someone has been, I was just talking with a trust and estate litigator yesterday about a case, and he had a case where an individual had been married, and then strategically he decided not to follow through on the divorce proceeding, but then remarried before he actually got the final divorce. So his second marriage was void as bigamy because he was married. So it's important to find out what these prior relationships are. And some civil unions or registered domestic partnerships automatically converted to marriage upon marriage equality, and that was by statute. So it changes from state to state. I do have on my intake form that for estate planning clients, whether they're married, and then I used to say state of marriage, and I've since changed that to a state in which marriage is celebrated. And the reason being, when I had one client who put state of marriage and responded solid. So I felt that I appreciated his dry humor. But the issues on whether to marry, so you do have clients, and there are a couple books out there that one is, I don't have their name, I should have provided that, Elizabeth Schwartz, she's out of Miami, and she had done a book on whether to marry, and once marriage equality came on board, and that's a great handbook. But income tax, how is that going to affect you income tax wise? Generally, if two high income earners get married, they're going to have a marriage penalty from an income tax standpoint. They're going to pay more in income tax. The tax code is, as for married people, is designed to benefit those and provides a marital benefit for those relationships where one person is either working in the home or has a lower income than the other spouse. And in those cases, you're generally going to have a marriage bonus income tax wise. You're going to get a tax break, but you need to run the numbers. If you don't have a CPA or accountant, you can do that. You can do some trial runs in TurboTax, but you always want to check that. The other issue is Social Security benefits. And while on our high net worth clients, they're not paying attention to Social Security benefits, but for our middle class clients, it's a big issue. And so when I marry, I'm going to get benefits with respect to my spouse's Social Security. And I will get, when I reach full retirement age and my spouse has reached full retirement age, I will be entitled to my benefit or one half of my spouse's benefit, whichever is greater. And that I refer to as living benefits. And when my spouse dies, I'm going to be able to step up to their benefit if it's higher than mine. If it's not higher than mine, then I'm stuck with my benefit. So those families, those marriages, they're going to have a decrease in income when that first spouse's death. The other benefit that you need to consider is if I was married for more than 10 years and then get divorced, I still have those living benefits and the survivor benefits of my ex-spouse as long as I do not marry. If I remarry, I lose those benefits, and there is an exception for survivorship benefits. I can remarry as long as I do so after age 60, and I will not lose those survivorship benefits. And it does not. Often I have clients say that someone is their stepmother or stepfather is trying to gain Social Security benefits on their father's Social Security account. It does not affect the other person. For example, when it doesn't affect that person's still going to get their full benefit, even though my ex-spouse is getting 1/2 of my benefit. And the other thing to consider, of course, is the marital deduction. If the client has more than the estate tax exemption, and they're going to be subject to estate tax, the marital deduction is very helpful. And currently, the estate tax exemption for non-spouse beneficiaries is $13,610,000. It's scheduled to drop down to approximately, it's a number adjusted for inflation, but approximately $7 million, and effective at midnight on December 31st, 2025, not that far away, but those are for more high net worth clients. So those are some of the considerations that you would have when, and I'll mention it again, when clients do get married, I always go back if they and check the title of their real estate, for example, and make sure that we have a deed as tenants by the entireties instead of just joint with rights to survivorship. But Danielle, are there any liabilities that come along with the marriage?
Yeah, so there's one in particular that I want to highlight, and it is something that tends to be North Carolina specific, though other states may follow along. And that's thinking about if someone has a chronic illness. So obviously, we all want to view marriage as in sickness and in health, and I'm certainly not saying don't marry someone because they have a chronic illness. But there are some liabilities that come with that I think people are not aware of. So the first, and this is not state specific, this is on a federal level, the healthy spouse's assets could disqualify the spouse in need from receiving government benefits. So if you're not married yet and your partner has a chronic illness and they receive government benefits or government support in any way, I would caution you to make sure that before you get married, your partner will not be disqualified from those benefits, or that if you do get married, you do not need those benefits anymore, because that is something that people, take a very long time to usually get those benefits and work very hard to save them, and so that's something that we want to consider. Now, shifting towards North Carolina specifically here, there is unlimited liability for a spouse's necessary medical expenses in North Carolina on the surviving spouse, or the living spouse. So if your spouse passed away and they had $1 million in medical bills and they needed all of that treatment, and their personal estate was $100,000, the rest of that bill goes on to the spouse. It does not die with them, as other creditors, would get paid out pro rata. The medical bills live on, and they attach to that surviving spouse. And this is something, we talked about earlier, prenuptial agreements, postnuptial agreements, being able to kind of dictate whether or not you're going to receive something when your spouse dies or not, and getting ahead of that now. This is something that cannot be contracted away. You are still liable, even if your spouse refuses to sign anything at the healthcare facility, even if you try to put a prenup or a postnup in place saying, oh, but I don't want my spouse to be liable for my medical bills. Unfortunately, that just does not work. It is not allowed. And so that is kind of an unavoidable liability in marriage. And not saying it's not a risk worth taking, but it's something that people should be aware of. And we saw that in a 2009 case Moses Cone Hospital versus Holly, that, you know, a husband passed away, wife viewed all of her real estate holdings and her other assets as her separate property, and she tried to challenge the medical bills that were brought forward on her husband's behalf towards her, and the court said, no, you're married, you accepted that liability, separate property or not, you know, this is not a separate liability, not a separate bill. And so that's something that is worth considering when you're deciding whether or not to move forward with marriage. And so, Paula, you know, talking about marriage, and we already touched on it a bit, what's going on with the decision in Dobbs, and how are we feeling about marriage equality moving forward?
Thanks, Danielle. Yeah, so, and that was the earlier question, what there in Dobbs, the decision that overturned Roe v. Wade, Justice Thomas, in a concurring opinion, mentioned the tension at the Supreme Court, as the lawyers know, but particularly for the non-lawyers in the audience, whether there's a right to privacy under the Constitution has been a issue that has the conservatives on the court have there are some conservatives on the court that take the view that the Constitution provides no right to privacy, that there's not a constitutional right to privacy, that because it's not expressly stated in the Constitution. So Justice Thomas, in his concurring opinion in Dobbs, said it was not a majority opinion, but it's Justice Thomas's opinion that he wanted to revisit those cases that were based on a that right to privacy, and and among those decisions that he mentioned was Griswold versus Connecticut, which was a 1960 case in which the Supreme Court said Connecticut could not ban the sale of contraceptives to married couples. And there used to be bans on that in Connecticut. And also, he did mention the Obergefell decision. So, but that is a concurring opinion of one justice of the 9 on the Supreme Court. Marriage equality, those individuals who have married, they have property rights, they have vested rights by reason of that marriage. I think it's going to be very difficult to reverse course on marriage equality. Not impossible, as we saw when none of us expected Roe to be reversed, but I think that it would be extremely difficult. There were, I did have some clients who were concerned about that. A lesbian couple, they had been in a long-term relationship. Once Obergefell came about, I'd done their estate planning, they came and wanted to talk about whether they should marry or not. And we looked at those issues that Danielle and I just went over. And the one issue that led to not getting married right away was the marriage penalty. They had their CPA run their income tax returns as if they were married, and there'd be a substantial marriage penalty. But given after the Dobbs decision, they decided that, hey, maybe they do want to go ahead and get married and solidify their relationship, which I think there's nothing adverse in doing that. It was interesting. I did tell them, well, I said, you know, they were thinking of getting married towards the end of the year. And I said, well, if you wait till 12:01 a.m. on New Year's Day, you'll still get one more year without that marriage penalty. So the marriage occurred in a church in Atlanta. They had a relative in Atlanta who was a minister, and we went to an Indigo Girl concert and in Atlanta. They were playing with the Atlanta Symphony on New Year's Eve, and then we went back to the church. And at 12:01, the marriage ceremony took place. And so they were able to get a little tax planning in with their wedding. And they always joke with me about that, and that they appreciate that they're able to put that together. So I think overall, that's if you're contemplating getting married, there's certainly every reason to. I think it's a great way to solidify a relationship. If you're worried about the sanctity of your marriage, your existing marriage, I think under Obergefell, that is that's going to be a very difficult precedent to overturn. Again, nothing's impossible, but it would be highly unlikely. Danielle, what about while we're talking about family, what about parents in the LGBT community? What issues should they be aware of?
Yeah, so I think the main takeaway that we want to instill in this section of this is the importance of the non-bio parent obtaining an adoption decree. So I'm going to repeat that. The non-bio parent should obtain an adoption decree. And so the reason for that is, people think, oh, well, I'm listed on the birth certificate. I'm not the biological parent, but I'm listed on the birth certificate. A birth certificate is only a presumption of parentage, and it can be rebutted by DNA evidence. So the only way that we think right now you can really solidify your rights is if you get an adoption decree. And so that can be a step parent adoption, it can be a second parent adoption, but at the end of the day, an adoption decree is a court order. And that is what is going to be entitled to full faith and credit in states across the United States. So some alternatives that people have been considering are co-parenting agreements, or VAPs, voluntary affidavits of parentage. And those can work in progressive states, but they're authorized by statute, but they're still not a court order. So they're not going to have the same staying power as an adoption decree would. And so a typical pattern that is seen with bio parents and non-bio parents who do not have an adoption decree is the bio parent moves to an adverse jurisdiction, a jurisdiction that's not going to recognize the VAPs or the co-parenting agreements, and they challenge the rights of the non-bio parents who didn't have an adoption decree in place. And so that's something that is important to consider. We want to make sure that we're having children with people we're going to be with forever, and it's a big happy family, but we always need to prepare for the worst. And we know that you want to keep your kids, right at the focus. And so getting an adoption decree for a non-bio parent is extremely important. And Paula, if you want to elaborate on that a little bit with some cases that we've seen recently.
Yeah, there's a great case for that should be encourage everyone and every non-bio parent to get an adoption decree. We just never know when a relationship is going to end on bad terms. And in VL versus EL, there's a U.S. Supreme Court decision in 2016. And what happened was EL was the bio parent, moved to Alabama. And Alabama is a very conservative state. Their Supreme Court was looking for an exception to the full faith and credit clause and did not want to recognize a Georgia second parent adoption decree. And the U.S. Supreme Court said in a per curiam decision that Alabama had to recognize that Georgia decree under full faith and credit, period, end of sentence. So had that couple had a co-parenting agreement, had they had a VAP, a voluntary affidavit of parentage, they could have possibly won, but even if they did win, there would have been tremendous legal expense. So even though a step parent adoption or a second parent adoption may create a little bit of expense fee-wise, it is the gold standard for parents, particularly in the LGBTQ community. And why is a birth certificate just a presumption of parentage? Well, prior to marriage equality, there are a lot of couples, maybe a putative father is able to prove that he was not the actual parent through DNA evidence. So the presumption in marriage certificate would be overcome. And there's all that case law that could work against a non-bio parent, even a committed relationship where they acknowledge the parentage. So that's just super important. And the other issue that we want to make sure we think about is if you're not, if you don't have that adoption decree and you don't, or you're not a adoptive parent, then make sure if you're traveling with a minor child, with your partner's minor child, that partner's given you written consent to medical treatment. And of course, if there's another parent involved, you're going to have to address that issue. I see that there's a question, and the question is, if marriage equality is overturned, will formerly married spouses need to redraft all of their estate planning documents? And that's, I guess I would say, if that happened, you would want to revisit your planning. But we did that before. So when I came out in the community, it was 2011. It was 4 years before marriage equality. There are many ways that we could preserve property rights between same-sex couples, and it was more cumbersome. It was frustrating, and they didn't have all of the rights of spouses. But yes, if Obergefell were overturned, but again, I would emphasize it's extremely unlikely. So I would not be redrafting documents. One thought that I've seen out on listservs, or that was raised, that I've seen raised as well, if you're drafting a deed for tenants by the entireties, which is what spouses do for a married couple, should you put a savings clause in there that says, if our marriage is invalidated in the future, we hold this joint with rights of survivorship? I would say absolutely do not do that. I used to do bankruptcy work, and if one spouse needed to file bankruptcy, tenants by the entireties provide some real robust asset protection, and you're just putting a chink in the armor. And the lawyers it may resonate more with the lawyers than the non-lawyers, but when the law is not all black and white. And if I file bankruptcy, a bankruptcy trustee is looking for assets that they may be able to seize to pay my creditors. So I want to make sure I don't put any chinks in that armor. So for now, I wouldn't be drafting documents with saving clauses, but clients, their documents need to be fluid. When we talk about powers of attorney, our powers of attorney provide a lot of flexibility, as I'm sure Danielle's do, that the attorney in fact can change documents. So even if you're incapacitated at the time that there was some reversal of Obergefell, we could still do some workarounds. In the 2 minutes that we have left, I just want to, at the risk of speed reading, I want to mention just a couple of things to keep in mind. And the Affordable Care Act has a non-discrimination provision. There's final regulations that were issued in April of 2024, this year. There's been a recent injunction. I think it was a recent injunction by a conservative federal judge out of Texas. So we were going to have to wait and see how far that rule, but that would prevent healthcare providers from discriminating based upon sexual orientation or gender identity, among other things. There are hospital visitation rules. So if you're in a hospital, you cannot be kept from your partner, and those are a condition of Medicare, Medicaid qualification. So a hospital would lose their Medicare, Medicaid qualification. Again, you can avoid a lot of that problem by having a good healthcare power of attorney in place. And then finally, the Bostock versus Clayton County decision by the Supreme Court in June of 2022 said for employment discrimination, discrimination based on sexual orientation or gender identity is unlawful discrimination based upon sex. So that's a very favorable ruling to the community. Danielle, in the time, I think we're out of time, but did you have any final comments?
No, just that, we are thankful that everybody came today and are excited to be a resource. And if you guys do, have questions or something and you want to pop them in the chat or something, still, Alex could shoot them to us later or something like that. But otherwise, I think hopefully this was helpful to everybody.
Thank you so much, Paula and Danielle, for sharing your expertise with us today. And thank you to everyone who attended. If you have additional questions, it looks like we're getting a couple of
Can we stay
comments.
online, Alex? Can we stay online and answer them, or do we do that offline?
I will stop the recording. Let's see, we've got one. that's just a copy of, or requesting a copy.
Yeah,
of the
I
document.
saw those out. I think I can get those. I saw Ron had asked for something, and Donna has asked